demarcation?
Well, I think it's appropriate for Congress to legislate, and I think there are potentially judgment calls to be made with respect to where you draw that line of demarcation. One of the points that I would make is that now in Guantanamo there are about 180 individuals. There are cases that are pending before the courts on behalf of most of those individuals at Guantanamo, and I believe all the individuals who want to have a habeas corpus case have a habeas corpus case that's pending. And I do think you become pretty close to the line of where Congress oversteps its bounds when you're dealing with such a finite group of cases that are already pending in adjudicatory judicial proceedings. For Congress to go in and legislate in that context, to me, represents some considerable constitutional claims. Now, could Congress constitutionally come in and do some broad brush legislation that would pass constitutional muster? I suspect they could. But to what benefit? I believe the judges have this under control. I believe that with the guidance of the DC Circuit, there is a uniform and consistent pattern of process as well as substantive law that is being fleshed out. And I think that if Congress were to interfere with the process at this stage, it would do more harm than good, create more confusion than it would answer questions, and ultimately result in much greater delay for men who have already endured far too much time without the process that they're entitled to.
Thank you. So now we open it to the audience. Please state your name and the organization. Yes, please.
My name is Richard Gerling, Dutch Embassy. I have many questions, but I will limit myself. One of the things that has come again and again on the table where it was as to contesting habeas cases, it was that both parties, so the defense was not allowed to see all the evidence, and that the government was using secret evidence or evidence that could not be revealed. Has this played out in your case, and how did it play out? And the other thing is, will some of these cases end before the Supreme Court?
Well, I can give you the experience that I've had with respect to your question about secret evidence, and maybe I'll let Judge Sessions deal with the question of the Supreme Court, because I think he's closer to that than I am.
Not much, if at all.
But the question of secret evidence was indeed an issue that has been part of these cases. And in our case, I don't believe it was a factor at all. There is a provision under the case management order that Judge Hogan fashioned where the government can, in certain circumstances, make filings of documents under seal before the judges. But it's my observation that the government is reluctant to do that the judges are reluctant to receive such evidence, that such evidence, in our case, there were some filings that were made under seal, but it was clear to us from comments from the judge and from information that was provided to us by the Department of Justice lawyers that what was filed under seal did not go to the merits of our case, but rather went to collateral issues such as discovery. And Judge Kennedy, under those circumstances, I think was more willing to take those matters under seal. Now, we objected and asked that they not be received under seal and that they be made available to us, but ultimately they were received under seal, but I do not believe they had any impact on the merits of the case, and I suspect that there may well be times, and our case may have presented that, where certain evidence is not necessary for a merits determination of a case, may be classified at a level higher than the classification, the security clearance that I hold, and so an under seal filing may be an appropriate thing to occur. But I don't believe, and I have not heard among my fellow Guantanamo Habeas counsel that the concern about secret evidence being presented to the courts is a significant concern in the proceedings that have been conducted thus far. And I see one of my colleagues, Christine Husky, in the back, who has a lot of familiarity with that. And she's nodding in affirmation, so I'm more comfortable. But on the Supreme Court, Judge Sessions, what's?
Oh, I have other observations other than the Supreme Court. I would say this, that in criminal practice, criminal law, cases in court where there is sensitive information or information that the prosecutor or the government in this case does not want to reveal and wants protected. And there are procedures in criminal law to do that. There are procedures here to do that. And they are under the case management section. If you'll turn to your report, go to section 6, where this report says the district courts have developed a cautious and workable set of procedures for the resolution of individual cases. And then under there, under the section B there, you'll see the district courts have developed clear and consistent discovery standards. And under that, you have 1, 2, and 3, the duty to disclose exculpatory evidence. Well, in criminal law, in the federal system, that is, and in the state systems as well, that is absolutely sacred. If there's exculpatory evidence that is not revealed by the prosecution, they risk losing their prosecution. They risk admonition from the court, and they risk contempt by the court if they hide that. They risk reversal, all those things that are an anathema to a prosecutor, absolutely. Under 2, it says duty to disclose evidence relied upon by the government. The government can't play swift and easy with those rules. It cannot, nod and smile and say, we're not doing that. The farmer says his eggs are fresh, but they're rotten. And so they have a duty to, if that happens, if it's relied upon by the government, the court will examine it. And Doug can probably tell you, Mr. Spalding can probably tell you precisely how it's done. The third section is the one you're driving at, and that is additional discovery can only be given if the detainee, the person who is seeking the writ, can show good cause. So the government can't shift it and play it under the table and let the court have it. So I think that's a precaution that you're wise to look at. I would say this, and if it's a comment really on what you'd said before, Doug, and that is justice delayed is justice denied. And habeas corpus is designed to cut through as much of that as is possible. And the delay, you can see why the delay happened in those first cases and why he suffered delay. The definition of the things that had to be done and had to be considered, the list wasn't complete and the action wasn't complete. And it took a lot of hard work on counsel and by the courts to get it done. Then you have an imprimatur of the Supreme Court that says, you have done correctly, now go and devise the procedures to protect these things and do it, and of course do it swiftly. If we were to go instead, if the Congress decided to give some other absolute jurisdiction, all that was done under that system would have to be perfected, would have to be reviewed, would be absolutely unavoidably delayed. And sometimes, people want delay. Sometimes the government wants delay. Sometimes the detainee, the defendant in a criminal case will want it, but you seldom find a person who is a detainee